My name is Edward Blum. I'm a visiting fellow at the American Enterprise Institute and the founder and director of the Project on Fair Representation. Well, it's hard for me to get a good feel on what the politics of the bench really are. And I use the last 3 days of last term as an example. The court came out on Monday, June, I believe the 24th, with the Fisher case in a 7-1 opinion, sending it back with a much higher standard to be applied for the use of race in university admissions. The next day came down the Voting Rights Act, and then the following day came down the gay rights cases. It seems to me that the court wants America and our legislative bodies to get out of the classification business. They want our institutions of higher education, our government, to stop classifying people and treating them differently, whether it comes to race, ethnicity, or their sexual inclinations. And I think that that's a trend that we've seen develop over the last 10 or 15 years, and I suspect it's going to be a trend that we see continue as long as we have this court. When it comes to race and ethnicity, I think the court has been, over the last 25 years, slowly and carefully, probably beginning with Croson, moving the nation to a point that the use of race and ethnicity must be fully abandoned by some end point. I'm not necessarily talking about Justice O'Connor's 25 years with the Grutter and Gratz cases, but each opinion seems to add incrementally to a body and a doctrine that the court is signaling that race and ethnicity needs to come to an end. I think that has accelerated over the last 7 or 8 years, but I think the trend lines have been in place since at least Croson in the late 80s. I think there is, great passion about the makeup of the court among both liberals and conservatives. And I think that's emblematic about, as we see in the debate about who should retire and when they should retire. So I'm not arguing that the makeup of the court doesn't mean anything. What I am arguing, though, is that the members of this court and future members of this court are on a historical arc that I believe will bring our laws and our public policies away from the use of race and ethnicity, more toward an ideal in which race and ethnicity are simply not factors at all. Well, my real interest in education, again, began back in Houston in the 1990s when I received a phone call from some parents whose children had been denied admission to a Houston Independent School District magnet school. This school was designed for kids who were academically gifted, and there weren't very many of these academically gifted magnet schools in HISD back in the early 90s. The mother said that her daughter had applied and taken all the exams and was told, however, that the school set aside 60% of its slots for African Americans and Hispanics and 40% of its slots for Anglos, and that the Anglo slots had already been filled. Well, quotas are anathema to our civil rights laws. Racial balancing is anathema to our civil rights laws. This wasn't something that HISD hid from anyone. It wasn't something that they were trying to achieve kind of with smoke and mirrors. This was quite prominently posted. This is what the outcome of this school is going to be. I hired counsel, recruited counsel. We filed a lawsuit against Houston Independent School District. 4 days before trial, HISD came and said, "Well, you're right. We're not going to go to trial. We're going to admit these kids. We're going to end the quota, and on top of that, we are going to take resources and open up 2 or 3 more campuses throughout HISD to accommodate kids of all races who want to be in a vanguard and an elite academic environment like this." So that's a pretty good outcome. That's a happy outcome. No trial, which is always a happy outcome for lawyers. More schools that will accommodate these kids, and the end of racial quotas and balancing in a public institution. Well, I got from Houston Independent School District to Fisher via Grutter and Gratz. Grutter and Gratz were not my cases, but of course I was deeply interested in them and deeply saddened over the Grutter case, in which the court decided that racial diversity was a compelling governmental interest that allowed universities to classify students by race and treat them differently by race. I think that was really a defining moment for many of us who labor in this movement, that opinion one day hopefully would be revisited. It was interesting that the day that opinion came down was the day that the University of Texas announced that they were going to add racial classifications and preferences to their race-blind admissions policies. So Grutter led to Fisher because the University of Texas decided that it was going to reintroduce race-based affirmative action on top of a race-neutral, highly effective top 10% plan that had been in effect at UT for the prior 7 or 8 years. That moment, that announcement, was basically the beginning of the Fisher case. Well, finding students, 17 and 18-year-olds, who have been rejected from the school of their dreams, who are now about to begin a 4-year college career someplace else, and persuade them to file a lawsuit challenging the admissions policies of the school that rejected them, is indeed not an easy thing to do. It's not easy to persuade teenagers to do this. It's even harder to persuade their parents to do something like this. So, whether it's the Project on Fair Representation or the Pacific Legal Foundation or Institute for Justice or Defenders of Wildlife or any of the environmental defense groups, one has to cast a very wide net in order to find someone like this. I did a number of different things. I launched a website called utnotfair.org. I gave speeches at the University of Texas and other college campuses. I networked. I cold called. I made a nuisance of myself, and ended up with a handful of decent prospects. Abigail Fisher's father and I had been acquainted from my years in Houston, and Abby turned out to be the ideal plaintiff. There were others that I could have chosen prior to Abby, but I chose not to. Variety of reasons. 1 or 2 academic backgrounds weren't nearly as meritorious as I wanted. Also, you have to find kids and parents whose heart is in the right place. These are issues that are very sensitive and polarizing in our nation today. I have to find people who are of good wills, who do not have an axe to grind, who don't have theories about the state of American cultural affairs and are going to use a lawsuit as a platform to share their ideas about American society. So Abby and I think the other individuals that I've provided counsel to have fit the bill of good hearts, the right motivation, and turned out to be, very sympathetic, ideal plaintiffs. We're a litigation organization. We speak to the courts, and it is often inadvisable for plaintiffs to speak outside of those courts. Judges read newspapers. Justices watch television. The last thing that anybody in my business, and whether it's litigating race or litigating the environment or litigating gay rights, is to have plaintiffs that are unsympathetic. And so I think it's very important to find just the right people to go before judges and justices.